ready to go?
Yes, please.
Okay, thank you very much. Yeah, and thank you very much for your interest in today's topics. I prepared two presentations. One is based on a workshop we had at Kyoto University on the Digital Markets Act, and it's originally based on a commentary project where I'm working on together with Professor Eckhard Bühren from Göttingen University, and it's part of a larger commentary. You may know in Germany we have those commentaries on individual statutes, and there is a there are 2 or 3 main commentaries basically for competition law. And for one of these, the Münchner Kommentar Wettbewerbsrecht, Eckhard Bühren and I are part of the team contributing the comments on the Digital Markets Act. This commentary is going to be published in the first half of 2023, and we also expect to make a translation of the main findings for an English publication, but the original publication will be in German. And for that new piece of work, we had to go into the details of the Digital Markets Act to understand basically how it functions, and it was my impression that we found out also a bit about those mechanics basically of the new statute that go beyond what you can read in scholarly articles before now. So for that reason I thought it might be of interest also to you. And I will start with an introduction of the European Union's thinking about the digital ecosystems and the way basically the Digital Markets Act addresses these structures. Then I will go through the questions we addressed at Kyoto University, which go also already a bit deeper into the matter. And my second presentation will be then on a separate aspect that is, however, related to the Digital Markets Act, and that is access to data and data sharing. Because we experience at the moment the emergence actually of a whole new set of regulations for digital markets, and that includes particularly regulation on data. And that is actually also a new type of regulation, so it might be of interest. So, but let's start with the Digital Markets Act. You can disregard this not in oral presentation because I would like to briefly introduce also into the relevant characteristics of the digital economy and the concept of digital ecosystems and cross-market power. Okay, so then let's start with the relevant characteristics of the digital economy. The next slide. There we already can take into consideration, next slide please, that data is important throughout the digital economy. Data is an information carrier. It can reduce information problems, market failure, and it can also reduce transaction costs. If you consider internet transactions, right, they get much more efficient through the use of data and the quick processing of data. And if we consider this overall, then we can also say that digitization, so just the translation of everyday life's facts into bits and bytes, is contributing to an acceleration of transaction. So next slide, please. Data, however, also then has market effects. So on the one hand, the internet reduces the cost of transactions and of information, which allows new markets to evolve. Think of, for example, online search. As long as we didn't have the internet, when you wanted to look something up, you had to ask, you had to go to specialized information providers or looked up in a telephone book or whatever, but it was different sources and it was difficult. now it's the results are literally one click away. However, also existing markets can be transformed. Think of, for example, hotel and flight booking, much easier over the internet than before. And then we notice that there are three pillars, basically, on which online transactions rest. One is data, as I said before. The other one is the use of sophisticated algorithms to analyze and exploit the data. And the third one is the actions of online platforms as information and transaction intermediaries. If we go to the next slide, then we can take a look at the same issue basically from a competition law standpoint. And there basically we can apply the same rules to data that we are used to apply to information exchanges, right? So when we consider, for example, oligopolies, or when we consider cartels, we know that the more the information has a strategic value, the more it can contribute to an alignment of competitive interests. But that first of all means the more it has relevance basically for competition. So if we use the same concept for data, we can say that data can have an impact on competition, first depending on the market structure, then depending on the quality of the relevant data, how much does it actually tell you, and also the quantity of data flows, just like information exchange. The next thing is then the algorithms that can be used to automatically process the data, and platforms that use also algorithms, but at the same time centralize market organization. Think of online marketplaces or search platforms where really consumers and other users flock to the same platform operator to exchange information basically on social networking, on products to buy, on hotels or flights to book, or to search for anything else, or to provide information about that. So we see that on the one hand, this is all very beneficial. We have an increased transparency, which allows markets to function more efficiently. But on the other hand, we have a reduction of market failures, which again can lead to an emergence of new markets. Think here, for example, of Airbnb. Private persons may have a room to rent out, but they would not do so because it's costly basically to organize everything. And now Airbnb steps in and says, look, you can just use my platform, which is very convenient, and make your room available just for a couple of days, and then you can stop again, for example. Or the same with Uber, at least the original concept, right? You have a car that you don't use all the time, but how to basically commercialize it would be much too costly, and now Uber steps in and says, you can use my platform, and you'll find a much broader market of interested people than if you just ask around who is interested in using my car. And so new markets can develop. However, at the same time, we also have a new risk of market failures, because in particular, those who can process the data have an advantage over those who cannot. And we know, in theory, it's both companies and also consumers that can make use of algorithms. For example, for consumers, you have price comparison tools, you have search engines that provide very powerful algorithms also to consumers, but still it is to be expected that the company owners may be able to invest more in their algorithms and to use them more efficiently. So we have new asymmetries arising between company operators and on the one hand and consumers on the other hand. And then we have particularly those platforms that step in between, commercial users and end users, which then can give rise to platform market power. Next slide, please. So over time, this situation developed very dynamically on the online market. For a long time, we thought that actually this could also hinder the emergence of permanent market power, even though we knew from the very beginning that platform markets may tip in favor of one platform operator, right? So you may still have hundreds of hotel booking portals around, so not every of these markets needs to tip, but you have nowadays Amazon as the strongest online marketplace. You have the Facebook platforms, Instagram, WhatsApp, and so on for communication services, social networking services. So there we have seen a permanent kind of concentration. And also for hotel booking, it may just be a question of time, basically, when just one platform takes over. But I'm actually not sure. How is the situation in Japan? Is it still a couple of hotel booking portals? So, but let's go back to the slides. Digital ecosystems. How does this concept now emerge? We saw that the large platform operators gradually built up cross-market structures where they would provide complementary and compatible services using the same resources, among others, the same data. Right? So if you have, for example, Google with its search platform, it uses the same data to improve its services, right? Data coming from the users about user preferences, but also who is actually the user, and so on and so forth. So they improve the search experience for users, but at the same time they can use the data to commercialize their service to via advertisements. And then it is just one step basically to say, okay, if we can also include a price comparison site, or we can build up an operating system for mobile services where we already think of what end users will be interested in using in the future, right? When they started developing the Android system, they knew that users were migrating more and more into mobile applications. So it was a reasonable step to then invest into building up the operating system and integrating that into their ecosystem. Same for Amazon or Microsoft, Apple, and so on. They know how to basically find out about the next emerging markets. However, at the core of that, you always have one or several platforms to which then other platform services or non-platform services can be added. And you may have, and that is what I wanted to tap in this second presentation, you may also have use of data storage that can be rented out to others, because the ecosystem operator does not need to use all the data storage all the time. Sorry. So moving on to the next slide. Over time, this combination of services using the same data can give rise to market power, but the feeling in the EU from a substance point of view is that we can also have a new type of power that develops that we cannot easily, at least, tackle using traditional competition law concepts. The traditional competition law approach would be we look at individual markets, and then maybe we also look at a leveraging of market power into other markets. However, for for digital ecosystems, we have to note that they can combine platform powers on individual markets and at the same time this exclusive data access and to the possibility to use data across markets, right? So what this slide says, it repeats my finding here, and at the same time it says, when we look at it from a traditional competition policy perspective, we can actually interpret this all in traditional terms. We can see that the platform digital ecosystem operator raises entry barriers by using these interactions of services and data, but it can also leverage its market power. However, we know from enforcement that making these findings is very difficult, also very fact-intensive, requires lots of investigative effort. Therefore, it may be easier to just consider the cross-market power as a power of its own. Yeah, so moving on to the next slide, I just wanted to briefly say basically how you would apply traditional competition law to these economic findings. Obviously, to the extent we have agreements, Article 101, TFEU, the anti-cartel provision can come into play. To the extent we have unilateral action, Article 102, the abuse of dominance provision can come into play. In all instances, we would have some kind of market power, so we need to keep that in mind. However, we also would have to consider that always there will be efficiencies, right? The whole business model has developed because platform operators were able to see that you can, by combining data, building up these services, reaching out to a larger audience, you can create benefits basically for everyone, right? The only question is then who gets the largest share of these benefits, but we need to take that into account. So the efficiencies coming along with these services are welcome. The problem is, however, what happens if we have such a powerful operator that does not want to share all those benefits, and that is able to also control access to the market via its platform position in between users, right? So it can use anti-competitive agreements, for example, price parity clauses, where a platform operator, like for example Booking, says, okay, please hotels, if you want to use other hotel sharing platforms, you must make sure that the price offered there for your hotel rooms is the same as on my platform, which would be an agreement and might hinder price competition for hotel rooms, right? Because hotel operators may then consider Booking to be so important that they just have to accept that specific clause and are not able to negotiate it. That may, over time, foreclose price competition completely. There the question is, again, obviously, how do you balance this with the efficiencies? Because, for example, Booking may say, well, if I don't impose this clause, then hotel owners will just free ride. They will benefit from me giving them access to a large end-user audience, but then they will offer users a better price, for example, on their hotel website or a competing platform websites, which is then basically depriving me of remuneration through commissions. Fair argument, but the question is obviously, when does the balance tip in favor of finding a competition infringement? So Article 101 may apply, Article 102 may also be violated if you have, for example, Google in this case, with its Android operating system and going to tell original equipment manufacturers, you need my operating system, I guess, and you may be free to use my operating system. However, if you want to have certain apps like YouTube or Google Search, or if you want to give access to the Google Play Store, then I impose certain conditions, which may help Google to leverage its market power, right? Because then the question is, which conditions does Google impose? But in any event, Google knows manufacturers will be desperate to have YouTube and the Google Play Store and so on their equipment, so they will accept the terms. So Article 102 may apply. It may be used to foreclose competition on certain markets. It may raise entry barriers to a point where Google may even safely start exploiting users. But also these practices can be used to further expand the reach basically of the ecosystem to leverage market power. So if we move on to the next slide, when we look at these things from the perspective of the enforcers, we have to note that they are in a quite disadvantageous position. Sorry. Particularly if we consider that the root cause for many of the problems lies in the fact who controls the data. And it's definitely the ecosystem operators that have many data, but not the official investigators, right, the enforcers. The competition authorities, however, bear the burden of proof in the investigation. So they have basically to define which access they need for their enforcement purposes. Then they have to force the ecosystem operators to share that the data, the knowledge of the data with them, and then they have to analyze the data themselves, even though they don't have the algorithms and so on and all the tools that the ecosystem operators have a grip on. So we see that over time markets tend to function less and less efficiently because digital ecosystem operators are able to influence the balance in their favor basically, and to expand the ecosystem without the competition authorities being able to really step in between. Also, competition authorities, as I said before, are forced to apply traditional competition law on a market-specific basis, which further increases their investigation, the requirements for proving an infringement. Last point, which also came up in the political discussion, is not so much, I think, relevant in the legal discussion, is what do we actually do about infringements when we find some? Because one possibility is then to just, prohibit the harmful conduct, but that if you consider that this may be conduct that makes market tip permanently in favor of one ecosystem operators, just prohibiting the conduct may not be sufficient, right? Because then the market has tipped, all the competition is destroyed, and tipping of platform markets means it is unlikely that someone else will take over the market. Originally we thought that tipped market could be just reallocated to new players if they have innovative products, better products, but now we know that through these ecosystem developments where markets are interlinked and the ecosystem operators control access also to these markets, it's very difficult for innovative companies to turn around the development. So if you really want to restore competition, this means that you would have to go beyond simple prohibition of certain conduct, but you would have to break up the ecosystem again to neutralize these linkages between the markets. However, if you do that, you obviously also destroy all the efficiencies that came along with building up the ecosystem in the first place. So this is basically how we got to the DMA. Now, as I understand, you already heard my presentation last time. Every one of you? Were they all present? Let's then move on to the DMA. And I will, before we actually get there, let me also make a brief comment on actually the relationship between the DMA and traditional competition law enforcement now, because I could not really specify. That's why I left that out to a large extent from this presentation. What we are going to see in the future, obviously, and that is an important question. I just explained to you that we have this problem. We may need to break up companies, right? At the same time, we may also have just an interest in preventing further harm to the markets. Now, the DMA is just about this preventive aspect. It is including conduct obligations, which can span very far, but it's just on conduct. It's not about structure. So once the market structure is harmed, the DMA does not do anything about it. Whereas competition law still applies. That is also basically from the legal hierarchy. It's unavoidable. Article 101, 102 TFEU take preference over all regulations and directives within the EU. So the Commission cannot do anything about it by just proposing a DMA. And the DMA is secondary legislation, it's a regulation. However, the Commission has not said clearly how it is going to use Articles 101 and 102 TFEU in the future. However, what we know is that Articles 101 and 102 TFEU reach farther than the DMA. They are not just about conduct, but they are about conduct that is harming competition in the market, so that is at least capable of producing harmful effects in the market. Now, if that is the case, then you can also use Articles 101 and 102 TFEU to restructure markets to neutralize the market effects that harmful conduct may have produced. Right? So it is well possible that the Commission will continue to use Articles 101 and 102 TFEU alongside the DMA. And the Commission also has made clear that it has a certain interest in that. We just don't know yet what it is going to do exactly. So with this in mind, let's look at the new regulation 2022/1925 or the Digital Markets Act. So I will go briefly through it because this is just an overview. This regulation is a new type of regulation, and it also is considered to be separate from traditional competition law. And I must also say, for a very long time, or up to now even, this idea of having regulation that is not competition law has been very controversial also within the law. The two objectives of the Digital Markets Act is protecting the contestability of markets, so not market functioning, but only the contestability of markets, and then fairness regarding imbalances in bargaining power. Contestability of markets, well, we may consider this to be indeed a valid objective if we consider that we are in this platform on ecosystem scenarios. We are in scenarios where we basically reach a point of permanent market failure. Now, competition law is about functioning markets, right? It's about, theoretically, even in the cases of abuse of dominance, you have functioning markets with one, well, market failure already there, dominance. However, we still consider these markets to be able to correct themselves. That's why we apply the abuse of dominance rules and hinder dominant undertakings to expand their market power further. If we are in these ecosystem contexts, we take into account that market failure may become permanent. And then we need to basically think about, okay, what can we do to protect the small fringe competition that may remain? And this is basically the contestability objective of the DMA. The fairness objective relates to the fact that within the ecosystem and within the platforms that exist in the ecosystem, you may have strong dependencies of users. Think of app developers, to take a commercial platform user for once. App developers may be desperate to be listed with their apps in the Google Play Store or the Apple App Store to reach consumers, end users, right? And at the same time, also end users may be hugely dependent on individual platforms. Think again, the App Store users that want to have certain apps, you need to have certain app stores to get them. End users may be even more vulnerable because they don't have any market power themselves and they can individually, and they are, for example, also exposed to exploitation when they use search. They don't pay for it, but they pay with their data, obviously, and so companies may collect more data without telling users about it, information asymmetry. These dependencies exist in a bilateral relationship. And the digital markets, and they are natural to these ecosystem scenarios. So the Digital Markets Act was conceived as regulation that focuses just on these two aspects. Then, as I said, it is a new type of regulation which shows itself in two aspects. We discussed, we discussed already that it's responsive regulation, right? So this is an aspect we need to take into account. Is working together with, it's taking into account potential reactions of ecosystem operators already in the design of the regulation. That is interesting, but we come to that a bit later. And what is more striking, and that is something you see immediately when you read the regulation, is very formal. It very often does not say what it actually wants, but it just limits itself to its core provisions, and you have to interpret it to a large extent. This starts already with the addressees of this in the regulation. It does not refer to any market aspect, but it just uses a very formal criteria to define so-called gatekeepers as norm addressees without any individual assessment, which obviously facilitates enforcement. It submits these gatekeepers to conduct the transparency obligations without any need to find any misbehavior like in traditional competition law. And it applies also, again, across markets for these conduct obligations. So the individual market situation is irrelevant, thereby also efficiency claims are irrelevant. You just apply very formally these obligations. And last point, concentration and supervision are concentrated at the European Commission level. There is some interplay with national agencies, but national agencies don't play such a big role. And that also actually makes sense if you consider that ecosystem operators nowadays design their business models at least for the entire European Union, usually for the entire world, but not for individual member states. So we are beyond that stage. So let's maybe skip the objectives of DMA remaining ambit of computational, because we have covered that already in its first questions, and move indeed on to the next section of this presentation, the DMA and other data related EU legislation. Now we can skip that, sorry, let's skip that one as well, and move on to the norm addresses. So yeah, that makes sense. I will cover this other aspect also in my data presentation, data act presentation. So for now, let's move on to the slide, the norm addresses, and there to the following slide. It's called designation of gatekeepers. Yes. Yeah. That is a bit too far.
Too far.
Yeah, that's too far.
23.
23. Yeah, yes, it depends on which slide that you use. So, what I wanted to briefly resume here is, reiterate here, is basically how does the DMA define norm addresses. Here we have a multi-layered system that has very general qualitative criteria, but actually proceeds from quantitative presumptions. So it's not being said what is basically a harmful entity basically acting on the European market that should be subject to the new rules, apart from the fact that it must be an entity that operates one core platform service, which makes sense because I said before those ecosystems usually have developed out of one core platform service. Now, otherwise, the new regulation just uses quantitative presumptions. It requires these potential addresses to reach a large number of users, 45 million, for example. That's a threshold for individual platform services. That is the threshold that is arbitrary. It's just 1/10 of the EU population, but it makes enforcement easier, and has remained controversial. And we'll have to see actually how the DMA actually will have, which impact the DMA will have on the market. It has been claimed in the legislative process that there are many more gatekeepers under this definition than the European Commission originally thought. The European Commission obviously wants to capture around 10 ecosystem operators, 5 to 10, which definitely include Apple, Amazon, Microsoft, Google, and Meta. But it might end up with even regulating Snapchat or Booking or others who we don't know yet, simply because they meet those quantitative thresholds. Now, once these thresholds are met, it's possible to counter the existing presumptions, to rebut these presumptions, but the burden of proof shifts. And even if the presumptions can be rebutted by demonstrating that they are not valid in individual cases, that doesn't mean the potential gatekeepers are off the hook, but instead a market investigation takes place. So you see, it's really different tools kicking in to make sure that everyone that should be captured is indeed captured by the new rules. Once this market investigation is being conducted, the Commission will also take into account whether gatekeepers are using circumvention tactics to evade them being named as addressees. So there is an anti-circumvention rule for splitting up services artificially, to just say, well, actually we don't have, for example, those 45 million users because our service is much narrower, and then you find out, well, actually it is 45 million users, they just artificially don't buy their service. if that anti-circumvention rule doesn't kick in, then it's still possible to make an individual assessment regardless of the quantitative presumptions to find out which companies should be designated as gatekeepers. And here, the regulation starts to differentiate. It also includes rules allowing to name a company as gatekeeper if it's just prospective. So if we consider it to become a gatekeeper in the near future, we can then already submit it to this regulation. However, then the conduct obligations for this prospective gatekeepers will be limited. And the Commission may reassess its designation or non-designation decision in case of particular events or on a regular basis. And that is a maximum rule, so it can actually assess the designation all the time if it wants to. Let's move on to the obligations. So we have here differentiated rules, which, however, apply without regards to the market situation, as I said before. One category, which we covered extensively in Kyoto, therefore I will keep it a bit briefer today, is designed after cases that have been launched already, not necessarily closed already. And it's the obligations are very much structured along the theories of harm of these cases. The next category are obligations that are specifically introduced to enable and facilitate multi-homing and switching by users, because we want to increase contestability, at least over time, right? So we have interoperability rules, we have data and service access obligations, and so on and so forth. And you may consider this symmetrical regulation in a way that it applies to all gatekeepers the same way, but it is asymmetrical if you consider it in a larger context of regulation. That is something we'll focus on when I talk about the Data Act. Last category is Article 7, a new provision that now imposes horizontal interoperability of communication services. And what does that mean? Well, when you use, for example, WhatsApp or like the LinkedIn chat or whatever, whenever this comes into the scope of the DNA, the ecosystem operator will have to make sure that you can use your own service to communicate with people from other services, which was hugely controversial, but in the end imposed basically by the European Parliament in the trilogue negotiations of this new legislation. It's remained controversial because economists say, well, it actually runs somewhat counter to the objectives of this new regulation. Think about it, if you have interoperable services, would you then still consider switching to another provider? Actually, no need, right? Because you can stay with your provider and still get access to other people you want, rather to have switching. But that is basically something we'll have to see how these new rules work out in the future. Article 12 allows for some flexibility, because all these obligations that I mentioned so far may be adapted to the circumstances in the future. And this is basically where this new regulation starts to become interesting, even though it is very formal and very structured. It itself allows for some changes over time. And next slide, that would be next second. This slide starting with the header ensuring compliance. Article 8. There, yes. A bit farther, yes, it looks like this. Yes. Article 8 is a particularly interesting aspect of this regulation, also seen together with Article 13, because it is a kind of rule that we don't have in European law so far. It's to some extent it can also be explained by the idea of introducing responsive regulation. However, we need to also here take into account that the DMA as such does not really say anything in addition to what really has to be regulated. So also here, it basically does not really say how this new rule will operate in practice. And from what you see in the regulation itself, it's actually not very responsive. In contrast, it is very one-sided. It starts with an obligation to ensure and demonstrate compliance. Now, that is an interesting rule because, and we can also take the next bullet here together with it, the compliance has to be effective. Now, this is interesting because the obligation to implement the obligations contained in Article 5 to 7 is already part of these obligations, right? So you don't have actually to write, okay, so I tell you do this and do that and do that and do that, and afterwards I tell you, well, you have to comply with these rules, not necessary. But here, the obligation goes beyond the original obligations of Articles 5 to 7, because the conduct must meet the objectives of Article 1. So the objectives of contestability and fairness. So it's not sufficient as a gatekeeper if you just, comply with the individual obligations by the letter, but you have to meet the objectives of the Digital Markets Act, which is something you could also try to read in the individual provisions, but it is already a statement that here you have duplication, basically, of obligations to make sure that really the objectives of the entire act are being met. And if there is non-compliance, well, then this means that you have either an infringement of Articles 5 to 7, if even not the letter of the rules is being respected or observed, or you have circumvention under Article 13. Both these violation/circumvention could then be sanctioned. Article 8 as such is not sanctioned. That is a weird aspect of this structure, but it is actually a fact. Now, Article 8 does not limit itself to these very strong obligations and the interplay then with circumvention, but it also allows for a specification of gatekeeper measures. And when the Commission published its draft proposal of the DMA, people jumped immediately on that. They actually did not discuss so much these very stringent obligations I just described, but they said, oh, that is weird. The Commission is starting a discussion basically on the obligations. And so we will have huge legal uncertainty, and also this rule compromises basically the Digital Markets Act as a very stringent statute. Now, indeed, already the proposal also included reference to a so-called regulatory dialogue, and this is where this concept of responsive regulation comes in. So basically, the Commission had in mind certain cooperation with the gatekeepers to ensure impactful and effective enforcement of the new rules. However, when you read the proposal, very carefully, you could notice that this regulatory dialogue did not actually refer to the, the specification did not really refer to the obligations of Articles 5 to 7, but only to the measures the gatekeeper takes to implement the obligations. So the obligations would be untouched by any specification. Only the gatekeeper could go to the Commission and ask, well, what do I actually have to do to meet the requirements? Now, there also this regulatory dialogue was being put in place. In the final act, the specification rule remains the same. So the specification only takes place with regard to the measures the gatekeeper has to take, not with regard to the obligations as such, can take place upon request, but in cases of a circumvention, it can even be imposed basically by the Commission regarding all the obligations we have in Articles 5 to 7. Upon request, it's only regarding Articles 6 and 7. Now, the informal dialogue, well, that is difficult. So maybe we can have a look at the question we had on this. 1 second. Yeah. This is a slide that starts with a question. And the question is, how will be the specific content of the gatekeeper's obligation be identified through regulatory dialogue? I would like to briefly go into the details of this question here, because this is indeed something quite intricate and new. In the final DNA, it's only one recital that still refers to the regulatory dialogue. And it says that the European Commission shall specify implementing measures following a dialogue with the gatekeeper. The DMA as such is silent on the dialogue and how it should operate. Now, we know that such a regulatory dialogue can be useful. It can, for example, provide for certainty regarding the design of gatekeeper measures. And it can allow to even provide clarity regarding the question when the Commission would intervene for non-compliance, right? And the Commission may, for example, take into account in this context that the gatekeepers may provide valid arguments that certain measures are producing so many inefficiencies that they cannot be accepted, or that in fact the measures contemplated by the gatekeeper may provide lead to additional efficiencies in comparison to what the Commission has in mind. Here it comes also into play that the gatekeepers still have the information advantage, right? So they may have valid grounds for certain conduct. It may not just be that they are always, interested in harming the market, but they may indeed have certain reasons in favor of consumers for certain actions. So this flexibility is possible through such a dialogue, but still also here the DNA does not really specify as such how this is all going to work. It just says there has to be this dialogue, and then it includes rules on the obligations and also on non-compliance and sanctions, but it doesn't say when the obligations will be enforced or when sanctions will be imposed and so on. Here we have flexibility, basically, which can be governed by this dialogue. And that is basically, again, this formal approach. The DMA very often does not really address those questions that are most important and interesting for the practical application of the new act. However, last point on the regulatory dialogue, and that is specified still in the act, no negotiations, basically in a way that the gatekeeper has a right to anything. It can propose measures. There can be communication back and forth, but in the end, it's a unilateral decision of the European Commission what is going to happen. which is in line with, for example, Regulation 1/2003 for cartels, which also is a one-sided tool, or even when you have, for example, commitment procedures. Now, if we go back to the second slide with the header ensuring compliance, so it looks just like the first one, but it's ensuring compliance too. I briefly want to also mention the complementary rules that have to be viewed together with Article 8. That is one, Article 13, which I mentioned already, which is about circumvention and includes a number of specified additional obligations to make sure that really gatekeepers abide by Articles 5 to 7. In addition to the circumvention rules regarding the designation of gatekeepers. But then we also have other rules that don't necessarily come to mind immediately when we read Article 8, but they still have to be viewed together with Article 8. One is Article 28, providing for a so-called internal compliance function. So gatekeepers will be forced to include a function within their organization that provides for internal supervision of what the gatekeeper is actually doing. And then we also have the sanctioning procedures and rules in Articles 26, 27, 29, etc., which are procedural tools we know from other regulations that complement the compliance obligations. And here, basically, then the balance tilts from a cooperative stance. I said it's no real negotiation, but still a bit cooperative, what Article 8 provides for, to strong unilateral enforcement, right? Because on sanction it's definitely only the Commission that needs the procedure and the enforcement. Okay, so maybe briefly, just to provide the full picture, let's move on to the slide headed additional obligations. There will be also an obligation regarding the notification of acquisitions and also an obligation to report on how consumer profiles are being produced within the gatekeeper. These two obligations clearly are just basic obligations. They are also very controversial, particularly the notification of acquisitions obligation, because Article 14, because there were many proponents in the legislative proceeding to even include a prohibition of killer acquisitions. Regarding the accountability of consumer profiles, it was less controversial, but it's going more to the heart of the gatekeepers' business models. If we consider that they are collecting data very often based on end-user preferences, so consumer profiling may be very important in the future, but that is a rule that is a bit difficult to comprehend at this point in time. Regarding the notification of acquisitions, I just want to highlight that that was covered in one of the questions, but we don't need to access the slide there on that. Within the rules on market investigation, there's one rule that says the Commission can also conduct market investigations regarding additional obligations for gatekeepers, and there is another rule providing for market investigations for non-compliance. It's Articles 18 and 19. And this latter obligation adds on the sanctioning rules. It's just the Commission can find out basically whether there is some non-compliance, and also to better understand the market. Remember, information asymmetries can conduct market investigations, also where it has a suspicion of non-compliance. In this context, it can even then find so-called systematic non-compliance. 3 times non-compliance means there is systematic non-compliance, and then it is entitled to prohibit acquisitions by a certain gatekeeper. Well, this might be also killer acquisitions. However, the question is basically whether this is indeed what was the purpose of the discussion on this new rules of notification of acquisitions. The non-compliance provision that I just described was introduced as a DMA on European Parliament and Council initiative to strengthen this Article 14 and to do something about killer acquisition. However, as I said, it is now introduced in a rule on market investigations for non-compliance. That means also that the prohibition of concentrations that is being foreseen in this new provision can only become relevant when it comes to ensuring future compliance. Yeah, right? I said the DMA is not about correcting any market malfunctioning. It's therefore also not being meant to deal with killer acquisitions specifically, which might further strengthen the ecosystem even outside those original obligations in Articles 5 to 7. It still is limited to these enforcing these obligations in Articles 5 to 7. Now the question is then, how can actually a rule for market investigation and so on and so forth contribute to the enforcement of Articles 5 and 7 regarding specific conduct? But a killer acquisition usually does not have anything to do with certain conduct, right? So therefore, it's very questionable, at least my personal understanding, whether these new additions really will have any practical effect at all. That's why I think we can leave that out here, because maybe it's practically irrelevant. As I said, it was more a political decision than it was included in the DMA at all. Okay, let's see. I think the other ones are just individual questions. So with your kind consent, I would finish now up on the Digital Markets Act, and we just open the discussion on the questions that you may have personally. Thank you very much.